Fire Away tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer, mediator, and founder of Rudner Law, Stuart Rudner.
Welcome to Season 7, Episode 7 of Fire Away. Today, I'm very excited to be joined by Andrew Elias. Andrew is a partner at Lerners, specializing in short and long-term disability denials, as well as insurance disputes and serious personal injury cases. We're going to talk about some of the adventures of dealing with insurance companies, as well as some of the common misconceptions when it comes to insurance, disability benefits, and the mistakes that employers and employees make. Including the fact that just because someone may no longer be eligible for disability benefits doesn't necessarily mean that they have to go back to work. So we've got a lot to cover. I want to get right into it. Thank you so much for joining me, Andrew.
Thank you so much, Stuart. It is a real pleasure to be on your show today. I'm really excited to have a conversation with you about all this stuff.
I think it's going to be great, and I know you're going to be helpful in clarifying a lot of the things that many of us don't really understand when it comes to things like disability benefits and accommodation, return to work. So before we get too deep into that, maybe you can talk a little bit more about what it is that you do.
Well, you said it really well, Stuart. I'm a lawyer who has practiced at Lerners Law Firm for a very long time now. And I've always done two things in my career. I've represented folks who were seriously injured, often in car accidents or things like that. But more nowadays, more of my files are LTD and long-term disability and short-term disability denial cases. And very often it is employment lawyers like you who put me in touch with folks who've had their claims denied.
Yeah, and look, this is obviously why I wanted to have you on the show, because there is often a lot of overlap, and we are often seeing people who may have employment issues, whether it's a termination or harassment or a failure to accommodate, but they also have issues dealing with their insurer, which of course is when I reach out to you so you can help them. But sometimes people aren't really clear on how to deal with that overlap. And when I say people, I mean both individuals and lawyers as well. So I think it's helpful to talk through maybe some of the types of situations that you are typically that you get involved in.
Yeah, so I have found over the years that I often have a really close working relationship with the employment lawyer in a matter. And now my clients are all plaintiffs, they're all claimants. So I see it from the employee side every time. The most common way that folks are introduced to me is that they have become disabled. Their doctor may have recommended some accommodations that their employer says they are unable to accommodate, or their doctor has said they just simply need to remain off work. The insurance company, this is one of the large LTD insurers in Ontario, will deny their claim. And frequently, maybe too frequently, the employer's response is a knee-jerk, well, Sun Life says you're not disabled. See you at work on Monday. Otherwise, we're going to have a serious conversation. And you can see that engages both the employment law issues and, yes, an insurance dispute with respect to that denial.
Yeah, I think, and you've taken the scenario out of my mouth, because I was going to talk about this, and I may well talk about this when I get to do my my quote unquote rant at the end. But this is really, really important. So I want to break this down a little bit, because a lot of employers, a lot of employers that don't have in-house HR, but also more sophisticated companies, tend to want to rely upon the insurer. So an employee says, "I can't work," and they're not sure whether they have to accommodate them, whether they have to give them a leave or not. So they rely upon whatever the insurer says. But I think it's important that they understand that the question the insurance company is answering is not the question that they're being asked to answer. In other words, and I'll let you explain this in more detail, the insurer is answering whether the person's eligible for benefits. Whereas as an employer, you need to answer the question, or you need an answer to the question of whether the person is able to work. And maybe I'll turn it over to you and explain why those are two different things.
Well, it certainly puts employers in a bit of a pickle, because The very reason why they would like an insurance company to administer their short-term disability program, even if they're funding it themselves, even if the employer is paying the benefits themselves, they still would like an insurance company to administer it because they do not want to get involved in their employees' health. And so the most that they typically, I think, want to hear is the employee can't come into work for the time being, is continually being monitored by his or her doctor, and leave it at that. But then they get into a situation where the insurer says, well, you do not meet a test under a policy. And the test under the policy is, I mean, it certainly shares a significant space with the question of whether a person can work. But because the test for disability is whether you can do, generally, it's whether you can do your specific assignment at work. Whereas the ability to work at for a particular employer could be in another position. It could be in an accommodated position. It could be on a part-time basis. If you are unable to do your job, you qualify for disability benefits. But by the same token, the insurer will have, as they apply the policy, they may take a position that you do not qualify for benefits under the policy. But unfortunately for the employer, that doesn't give them a pass on evaluating the matter themselves. Difficult for them to do that, though, when they've outsourced looking at medical evidence to the insurance company.
Yeah, I think, and we'll come back to why you shouldn't outsource it, but I just want to, clarify a couple of things. One, I think we should make it really clear that not everyone has disability benefits, whether it's short-term or long-term disabilities. That will depend upon the nature of your employer and what kind of agreement is in place. So you may or may not have these benefits at all. But even if you don't have disability benefits, it doesn't mean you have to go to work if you are medically unable to. It just might mean that you have to take a leave of absence that is not paid. And you may be eligible for employment insurance benefits, but that's a whole other issue. But the other point I wanted to come back to is that someone may not be able to work, but may be declined benefits for another reason. For example, if it's a pre-existing condition or something along those lines, they may not be entitled to benefits. Doesn't mean they can work. And to your point, Andrew, this is why the employer can't simply take that letter from the insurance company and say, oh, well, he didn't get benefits, therefore you got to come to work. And we've talked about this on Fireway before, but I think it's important. I'll mention it now. When we work with our employer clients, and we see a lot of these issues lately, a lot of them now with medical, psychological, mental health issues, stress, anxiety, depression. We always work with our clients because they cannot ask for the full medical file. They can't ask for the diagnosis. You never want to know any more than you need to know. And from an employer perspective, all you need to know is what are the limitations on the employee's ability to carry out their job-related functions. That's the question. What are the limitations on your ability to do your job? And as an employer, that's all you want to know, because that answers the question of whether they can work, and if so, whether they need accommodation. From an insurer's perspective and the entitlement to disability benefits, and you can expand on this probably far more than I can, the insurer is going to want a lot more information than that.
Right. So a number of things you said. I mean, first of all, you're right. Not everybody has short-term disability benefits coverage. And for folks like that, there is the EI, Employment Insurance Sickness Benefit, which pays, it's fairly modest. It has a maximum of $668, I believe, dollars a week, and it lasts for a maximum of 6 months, which is approximately the same period that a typical STD policy covers. And not everybody has LTD coverage. So frequently, as you say, folks will have to go on unpaid leave if they are disabled. It is certainly the case that there are reasons that are not relevant to the employer's decision that can disentitle a person to benefits coverage. And you hit on, I suppose, the most common one is that pre-existing condition exclusion, because if you have not been employed at your job, and where there's a probationary period, if you haven't gotten through the probationary period, and then for a further year of coverage and employment, then any disability that arises that is in any way related to things you were treated for before you started that job isn't covered. But that has as you say, that has no impact on whether a person can actually do their job. But yes, employers do find themselves at a significant disadvantage because they will rely on the insurer's evaluation, but have no capacity to make their own detailed evaluation without, requesting an IME, an independent medical examination of their own, which, as we know, is not common at all.
No, I think that's a really good point. I know that's an area that's different from your practice and mine. Because I think in the insurance world, it's not at all uncommon to ask for an independent medical examination. In my world, it's extremely uncommon. It is really only acceptable where there's good reason to question the medical documentation that has been produced. For example, there was a case I was involved in a while ago where the treating physician went from saying that this person is utterly and completely unable to work, and then within a month issued another letter saying this person is able to return to work without any limitation. So in that case, the employer was a little hesitant, so they asked for independent medical examination. For the most part, you're not going to. But what I think is really important, and I'm glad you triggered this thought in my mind, because it's a really important point to make. We've all seen these generic doctor's letters, which say so-and-so will be off work for medical reasons for 5 weeks, period. Or so-and-so was off work last week for medical reasons, or whatever the case may be. There's no detail whatsoever. And a lot of employers assume that because of privacy laws or human rights laws, they can't ask for anything further. And this is one of those very interesting areas where employers underestimate their rights. Because you are entitled to details. And again, like I said a few minutes ago, you're not entitled to the diagnosis, you're not entitled to a full medical file, but you're entitled to know what the limitations are on the person's ability to do their job. And we have what we usually refer to as FAFs, functional abilities forms, which we use for this purpose. And it's a very standardized form, or there's a few variations of it, that we will work with our client to prepare. You send it to the employee is to take it to their doctor, or if you get permission, you can send it directly to the doctor. But either way, the doctor's got to fill this out. And it's got the details that you need. If it's a physical injury, it'll cover things like how much weight can they lift or how long can they stand. If it's a psychological or mental health issue, it's a little bit more difficult to be specific, but the doctors can provide information such as they have difficulty focusing, they need breaks every 20 minutes, or whatever the case may be. But you want to get that information, and you have to get that information. And if the employee won't provide it, and this is again where insurance and disability benefits are totally separate. From an employment perspective, if the employee will not provide that information, their absence is unauthorized. And that's when you can take an aggressive approach and say that if you don't return to work or produce a documentation, then your employment is going to come to an end. But that's a very different process than what you're dealing with, Andrew, when you're dealing with disability claims.
Right. Something we've seen more and more, and I'm not sure why, is employers being sued by employees over short-term disability benefits that the employer had absolutely no role in adjudicating. So they will ask a third-party company, still typically an insurance company, but also sometimes these workplace management companies, to evaluate all the incoming short-term disability claims. That company will make their evaluation, advise the employer that this person is not eligible for short-term disability benefits, and then the employer will go and get sued. And they will say, well, what did we do wrong? We entered into a contract with a highly experienced and capable, administrator, and we followed their recommendation. But not only are they liable because the benefits that the employee asserts they're entitled to are in the employer's pocket, regardless of why, they may be the only necessary defendant in the action. Because in that case, I would certainly take the position that the insurer is really just acting as an agent of the employer. In the same way any agent of the employer can act in ways that expose the employer to liability as the principal. so does an insurance company or administrator expose them to liability. So we see that all the time where an employer says, what did we do wrong here?
Well, it's a really good point, and I think I would agree with you that if there's going to be a claim made, it's going to be a claim against the employer. I suppose if the insurer had messed up in some way, then the employer might be able to bring a third party claim over against the insurance company, but that's between them. And I think the important point here is that the arrangement you're describing, where there's a disability benefit plan, that arrangement in your scenario is between the employee and the employer. And if there's a failure to pay, the employee is going to go after the employer. And it actually brings up another topic which we hadn't talked about before, but it's related to this, and it's an interesting one. I was going to say often, I'll say pretty well always see the scenario or when somebody is let go, and typically the termination letter will say we're going to continue your salary and most of your benefits for a certain period of time, whatever that period of time is. But when they define most of your benefits, it will always be health and dental, but it will exclude disability coverage and perhaps life insurance and out of province travel insurance. And what I find fascinating is that for decades, long before you and I started practicing law, this was just accepted, even though the law always said that during your common law notice or severance period, you're entitled to all of your compensation. And that includes all of your benefits. So for decades, the law said you should get all your benefits. And yet the insurance company said, we're not going to cover you if you're no longer working. And nobody questioned that. And even when we had one case that dealt with it, which is probably about 15 years old now, if not more, and said that, no, the employer, if you as an employer don't continue the benefits, then you're on the hook for potential losses. And there have been cases, as you well know, where an individual lost their job, couldn't get their disability benefits, so sued the employer. And you're looking at an employer who, when they let the person go, all they were thinking about was severance costs. And now they could be on the hook for hundreds of thousands, if not millions of dollars in long-term disability benefits for the rest of this person's working life. And yet nobody really seems to pay attention to this because we're dealing with this on almost every single termination that we have. Smart employers will put something in their contract to limit their potential exposure, but for the most part, they don't. And this is always going to be a live issue.
Yeah, no, that's striking. I was not aware of the that fact of employment law, that the provisions that failing to continue LTD coverage through the severance period was unenforceable in that way. I suppose in the case of a termination agreement, it is enforceable.
It could be enforceable if there's an agreement. So the smartest way to do it from an employer perspective is to put it in the employment contract. Now, have a contract with a termination clause which limits your obligations at the time of termination. Second smartest way to do it is to let somebody go and offer them something and get a full and final release. Because once you get that full and final release, you're good. But otherwise, and we've had a number of cases now where that's, that exact situation has played out, and the court has always, over the last 15 years, said that the employer is on the hook for benefits. So it's a huge potential risk.
I'll tell you a striking related situation arises sometimes where an employment lawyer representing a worker, an employee, will resolve all of the issues between the employee and the employer, sign off on a fairly typical release that releases the employer from any obligation for X, Y, Z, possible claims that the employee might make. But the employment lawyer did not think to ask whether the employer was the payor of the LTD benefits. Because we do see, as you know, sometimes, particularly with larger employers, like some big multinational retailers, sometimes quasi-governmental or governmental organizations, the employer will enter into a contract with an insurer, but not to provide an insurance product, just to administer claims that ultimately the employer is responsible for. They call those administrative services only, or ASO agreements. So in the course of obtaining a very good settlement with respect to termination pay for a departing employee, the employment lawyer will agree to, or the employee will sign a release of anything that they might be entitled to, and then find out that they've signed away their right to LTD benefits. And in that case, that provides a risk even for the lawyer.
Yeah, I'm glad that you and I are on the same page. That's exactly what I was going to segue to. So I'm glad you made that point. It's a huge one. I mean, anybody settling any case should be mindful of all potential claims. But of course, because that's not a typical one, it can get missed. And I guess related to that point, I wanted to bring up another point that I know you were anxious to mention, which is what happens to potential entitlement to disability benefits if someone's let go, or to phrase it another way, just because you lost your job, does that mean you cannot collect disability benefits? So I know you wanted to talk a bit about that.
That is super important because it is one of the most important questions and maybe misconceptions that I see from folks. Folks believe extremely naturally that if they are not covered by their benefits plan at the time they apply for benefits, they're not entitled to benefits. And so you'll have a situation where somebody is let go before they hit the point, the day on the calendar when they're eligible to apply for LTD. Because of course there's the short-term disability period of 6 months. And so if they're let go, even before they claim short-term disability, but let's suppose after claiming short-term disability, but before claiming long-term disability, and let's also suppose that short-term disability is provided by one company and LTD, long-term disability, is provided by another company. They think they're out of luck and that their employer, by terminating them, has disentitled them to LTD benefits. But that is absolutely not the case. The date that matters is the date you became disabled. Your rights crystallized on the date you became disabled. Just the way, your right to have your dental work paid for occurs on the date that you got the dental work done. The date that your LTD entitlement for potentially, I mean, you hope not, but potentially the next 25 years, if somebody's 40 years old when they become disabled, crystallized on the day that they were unable to work due to their illness or injury. There is a striking case that I just want to mention. It's not a new case. It's about 6 years old. It was heard by the Court of Appeal, where it was the McIver and Pitney Bowes case. And McIver worked at Pitney Bowes. He suffered a really nasty injury in 2005, a back injury and a brain injury. He managed to hang on there for another 3 years till 2008, quit that job, took a job with another company, got fired there a year later, so 2009, asked his new employer, hey, I think I need to apply for LTD under your policy because I think the reason why I was terminated was because I wasn't able to keep up due to my injuries. They said no, because your injuries happened when you were employed by Pitney Bowes. You got to go on their plan, which was a Manulife plan. And so this guy applied for disability benefits 5 years after an injury, when he'd been out of the employer that he had that plan under for more than a year, and the court upheld the claim. The court upheld the claim. There was a 90-day notice provision, so he had to advise the insurer within 90 days of his claim. It took him 5 years for understandable reasons. He was able to do his job in the accommodative environment he had at Pitney Bowes. He wasn't at the new employer, and that made him realize he's been disabled this entire time. He's just been finding a way to work through it. So that's an extreme example of the fact that you most definitely do not need to be covered at the time you make the claim. You just need to be covered at the time you become disabled.
Yeah, as you put it, that's an extreme example, but a really important one, and a much more common example that we see all the time is someone is let go, and before they were let go, or even in the weeks after they were let go, they become disabled. And I think it's again really important to understand that all that matters is when the disability arises. And I talked a little bit about this, disability benefits will continue beyond the date of termination because there's going to be some sort of severance period. It might be short, might be long, there will be a period. And under the Employment Standards Act, this is Ontario, but it's similar in most provinces, the period, the notice period under the Act is deemed to be active employment for purposes such as disability benefits coverage. So in other words, if you have 5 weeks of notice under the Employment Standards Act, then for 5 weeks after you were let go, your benefits continue. And if you become disabled during that period, you're entitled to your disability benefits. So I cannot count the number of people I've spoken to who just assumed they couldn't make a claim because they didn't have a job anymore. And in most cases, that's when I pass them on to someone like you. But in some cases, I end up talking to someone years down the road and they realize what they missed out on.
Yeah, another one we often see is that in just about every disability policy I see come across my desk, there's something called a recurrent disability period, which says that if you are disabled due to some illness or injury, and then you stop being disabled, you're able to return to employment. But then you become disabled again within 6 months of the previous disability ending. You are entitled to go back on that previous disability claim, which matters a lot if your previous employment ended and you started a new job during that 6 months, because you show up like Mr. MacGyver at your new job and you immediately realize that you are unable to do this job unless significantly accommodated, and your new employer is unlikely, or not as likely, I suppose, as your old employer to be able to find accommodations for you. I mean, they just met you.
Yeah, no, I think that's a really important point. And of course, the duty to accommodate is always there. And we're not going to take another half hour and talk about that because that could form the basis for another show. But one of the things I wanted to cover before we wrap things up is what happens at the 2-year mark in the long-term disability. Because a lot of people get really confused when 2 years in, the person's been getting benefits, there's been no real questions, and all of a sudden something changes. And from the employer perspective, all they see is a letter saying so-and-so is no longer eligible for benefits. And that's when, to your point earlier, they often say, oh, I guess you can return to work now. And if you don't, then we're going to have as you put it, a serious conversation. So what happens at the 2-year mark?
So in the great majority of policies, there is on the second anniversary of either the start of LTD benefits or the start of the disability itself. So on the 2 years after the disability starts or the disability benefits start, it depends from policy to policy, the definition of what it means to be disabled changes. And the same symptoms and limitations may no longer qualify you for benefits. Because whereas for the first 2 years, which they call the own occupation period as a shorthand, you are disabled if you are unable to do the job that you had, the duties that you had at the time you became disabled. After 2 years, when the definition changes, you enter something they call the any occupation period, which is to say you are only disabled if you are unable to perform any occupation for any employer, not necessarily your old employer, that you are reasonably suited for by your education, training, and experience. And that's a common formulation, but it's always something like that. And so you see at 2 years, if you have somebody who is very clearly disabled from their previous job, imagine somebody who's a roofer, right? And they're swinging a hammer all day with a back injury. Nobody's going to say this guy can be back up on a roof swinging a hammer. But then you look at this guy's CV and he's worked in lots of offices. He's got some training and that sort of a thing. It's not unreasonable to expect him to adapt to a more sedentary job. And so the insurer says, well, you were disabled, but you're not anymore, even though your health hasn't changed at all. Now, insurers make a lot of that. And, here, my mild biases may be slightly showing because I do represent claimants. I will say that the change of definition, while insurers treat it as the absolute most important day of your claim, and you should expect your claim will only last 2 years, for most people, most of us have jobs and experience that are fairly similar over the years. I mean, you have to go back to when you were, a camp counselor as a teenager to find a job when you weren't sitting at a desk, looking at a screen, talking on a phone all day, right? And so if those are the sorts of duties that your disability, suppose it's a mental health disability, suppose it's a physical disability or a cognitive disability, if those are the sorts of duties that your disability precludes you from performing, what does it matter that the definition is now any job you're reasonably suited for? Because guess what? I'm only reasonably suited for the sort of job that I had before. I'll give you one more example.
Right.
Frequently, those change of definition clauses will have a qualification where they say, any job you're reasonably suited for that will pay at least 60% of what you were earning before. And we meet all sorts of folks. Some of the folks we meet have very high paying, high responsibility jobs. And 60% of what they were earning before, still a significant amount of money that you would not expect somebody still struggling with a significant disability to be able to handle. And so what matters the change of definition? I guess my message on this is people shouldn't just say, well, okay, and employers shouldn't assume that a termination at the 2-year mark means somebody's all ready to go.
Yeah, that's a great summary and a great explanation, because I think a lot of people really struggle with that, and even the ones who understand the general application. I think you've addressed one of the questions I often get. The question that I sometimes get when I explain the difference between own occupation and any occupation, they'll say, if I'm talking to a professional, they say, okay, well, does that mean that the insurance company can insist that I go work at McDonald's now? So at least you've clarified that with the 60% rule, which I know varies from policy to policy, but that's at least there is some minimum threshold. So that's really helpful. I am mindful of time. Before I wrap up, though, I do, first of all, I really appreciate you joining me. And I do want to give people a way to find you if they want to talk to you, or better yet, retain you. So what's the best way for someone to find you?
The last thing I'll say before I answer that question, Stuart, is that jobs at McDonald's are hard. The jobs that people think are easy, the hamburger flipper jobs that people talk derisively of, and I don't mean that you have, but I think people do that. Some of the hardest jobs that people have, harder than my job, staying on my feet all day, dealing with a flood of orders coming in. There are no easy jobs done right. Any job is hard if you're doing your best at it.
Oh, I literally just had this conversation on the weekend where I was talking to a child of a friend of mine who is just graduating from university, and she was talking about the wonderful tips she's getting working as a server. And I said, I could never get a job. I could get an office job. I'd get those every summer, but nobody would ever hire me because I was obviously not qualified to work as a server. So yeah, certainly don't mean to diminish any role like that.
Not at all.
That's often the comment I get, which is where the McDonald's comment comes from.
I know, but those folks earn every dime. Super kind of you to give me an opportunity to tell folks that I practice, as I said, at Lerners. That's LERNERS.ca if you want to find me there. You can call our toll free at 1-877-287-8784, or just Google me, Andrew Elias, on the internet. It was a real pleasure, Stuart, to join you today. I really enjoyed meeting with you today. It's always a joy to talk to you.
It was great. I really enjoyed it. I have to admit, I prefer talking to you over dim sum, which is where hopefully we'll have our next conversation. I would love to have you back again on the show. So thanks again for doing it.
Thanks a million.
Yeah. And now I'll take my turn to fire away. So I want to pick up on a topic that we discussed in season 7, episode 7 of Fire Away. And the point I want to make is that I want everyone to understand that there is a very significant difference between whether someone is eligible for disability benefits and whether they are able to work. Those are two very different questions with very different implications. And despite that, we still often see this scenario where employers make a very significant mistake, which is that they see a letter from the disability insurer. The letter is addressed to the employee, but they get a copy, and it says either you're not eligible for benefits or you're no longer eligible for benefits. But either way, the employer sees that and assumes, oh, okay, they can return to work. And they then message the employee and say, we understand that you're able to return to work. And if you're not back on Monday, then you're going to lose your job. This is a critical mistake because they're basically assuming that just because the person doesn't qualify for benefits anymore, that they're able to return to work, which, as we discussed in a lot of detail in season 7, episode 7, those are two very different questions. And there are many reasons why someone may not get benefits, but it doesn't mean they can return to work. And when the employer then goes ahead and makes the mistake of firing the person because of the fact that they didn't come back to work as threatened, then they expose the company to significant liability. First of all, severance, which, as we know, can be up to 2 years. But over and above that, they expose the company to liability for breach of the Human Rights Code because they've effectively just fired someone because they cannot work due to a disability. They have also exposed the company to things like bad faith damages or punitive damages. And we talk about these things a lot. And historically, the numbers were not huge, but we're seeing the numbers trending upward. And we're now seeing more and more cases well into the 6 figures. And of course, that's over and above severance. And then add on to that the legal costs the company incurs and just the resources that are wasted by everyone who is involved in an ongoing legal dispute, which of course, as we know, tends to last for months or years and certainly not days or weeks. So bottom line is, please, before you take any action, and especially before you let somebody go, and particularly before you let somebody go because of a medical issue, get advice from a lawyer that specializes in employment law. And I'll take the opportunity now to use one of my favorite expressions. If you think you might need an employment lawyer, you probably do. So that's all for today. Thanks for listening.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.